Vidyalaya, College of Arts and Science, Coimbatore. Now it's welcome address. Welcoming is an art of making people feel special and to be presented throughout. To make everyone feel special, I am pleased to invite Dr. R. Bhagiraj, Head, Department of Microbiology, to welcome the gathering.
Good afternoon, all of you. I take great pleasure to welcome all of you for today's webinar on IPR and strategies for academicians, organized by Center for Research and Development, IPR Cell, and Institution Innovation Council of Shri Nehru Vidyalaya College of Arts and Science, Coimbatore. So today's webinar is focusing to promote the teaching community towards IPR. At this great occasion, I am indeed grateful to welcome the chief guest, Mr. PREM CHARLES, founder, Allinnov Research and Development Private Limited, India. Is a principal patent agent, Inanse IP and Consultancy Services. Welcome, sir. I extend my heartfelt welcome to our management and management members. It's my honor to welcome the inspiring personality, our beloved principal, Dr. Bojan Subramani, sir. Welcome, sir. I welcome Dr. Muthukumar, Director, SNMV Institute of Management, heads of all the departments, and Dr. S. Meenatchisundaram, Coordinator, CRD, and Dr. A. Vijaychitra, Convener of IIC SNMV CAS, and faculty members and students. A warm welcome to all of you once again. Thank you.
Thank you, sir. I request to beloved Principal Dr. B. Subramani, sir, to facilitate gathering.
A warm good afternoon to all the members in this Connect. On behalf of all, once again, I welcome the guest for the day, Mr. PREM CHARLES, founder, Allinnov R&D Private Limited, India. In spite of his busy schedule and other activities, he is willing to give a need of our topic, IPR related webinar for all our faculty members. We wholeheartedly thank the guest for accepting our invitation and joining with us. And my dear faculty friends, we have been doing a lot of research work and proposals, all those things we have been doing, but we are little far away from IPR, all of us. So this is the right time so that all of us can get all the informations about IPR and all other details, how we have to make IPR and what are the necessary steps that we have to follow in the research area or the proposals or whatever, patent or whatever. So based on this kind of programs, we can enhance our quality of academic enhancement can be very well developed. So my request to all the faculty members to get benefit out of this session. And you can have any queries, very well you can interact with the expert so that entire faculty team can be aware of what is IPR all about. And my sincere thanks goes to Center for Research and Development, IPR Cell of SNMV College, and Institution Innovation Council for jointly organizing this IPR strategies for academicians. So we have been talking and discussing so many things, but this is a need of the hour. So understanding the need and bringing the right person for the right program will give a lot of happiness. So life is education and education is life. So throughout, since we are in academics, we need to follow what we need to update and we need to understand. Thank you very much. Thank you very much. Department of Mathematics, you can mute your mic. Yeah, thank you very much for, and I am sure this program will enhance the level of information on IPR, and we can have more such programs to make ourselves a better person. So thank you once again, best, and the organizer coordinators for all the CRD, IPR cell, they have started and working excellently for the development of faculty right? So wish you all the best. Have a wonderful webinar. And once again, I welcome all the members are connected here. Sir, the dais is yours. Thank you very much.
Thank you, sir. There is nothing more difficult to take in hand to introduce our guest to the gathering in a special way. In his regard, I would like to invite Dr. S. Meenatchisundaram, Associate Professor, Department of Microbiology, to introduce our chief guest. I would like to invite Vinod Kumar to introduce our chief guest.
Good afternoon, all present here. And I have a very pleasant duty of introducing our chief guest, PREM CHARLES. He did his BE Mechanical Engineering and ME Engineering Design at Anna University. And he did his MBA from UK. PREM CHARLES got 7 years teaching experience in mechanical engineering. Presently, PREM CHARLES sit on the managing partner and patent agent and managing director of Allinnov. That is R&D department. It is one of the top 8th rank of R&D organization in India, especially for IPR. And also chairman and co-founder of Greenbrain Global Education Services, and also director operations and stakeholders. His accolades and interests are recently featured by Daily Hand News, Entrepreneur Stories as a man behind India's surge in academic patents. He has published 2 books and a total number of Indian patents filed and published 27 and granted 9. He also published 2 international PCT patents, and he received IP award winner in 2017 and certified patent expert in MHRD and AICTE. PREM CHARLES is expert in production research, innovations and IPR for more than 100 institutions. Charles is a registered patent agent from Government of India. He presided over 150 training programs for students, researchers, faculties in various institutions across the different states of the country. Thank you for this opportunity.
Thank you, sir. Sir, now the session is yours.
So, thank you for the warm welcome, respected principal, the organizers, and my dear fellow faculty members. So, I'm indeed very happy in presenting today's session on intellectual property rights and the strategies for academicians. I believe it is my 158th session into intellectual property rights. So, I hope this session will be an eye-opener for all the faculty members and the participants in this forum to understand what exactly is intellectual property rights, and maybe I guess I can solve some of the myths and misconceptions that has been around across educational institutions across the country. So I believe it's time for us to get into the session without wasting much of time. So the mandatory disclaimer here is that all the informations, brands and contents of the presentation are only for educational purposes, and you're advised not to apply as such in real time, because when it comes to real time, there are many legal formalities and legal procedures to be followed out, and you may end up making something to be changed right from the beginning. So make sure that you always consult a patent agent or a patent attorney before doing something practically. And the brand's logos here shown are only for examples, and I do not have any purpose in promoting or deceiving any brand in any manner. Fine. So let's actually faster get into the subject matter, that is intellectual property rights. So when we talk about a property is something that we possess with ourselves as an investment or as a dream. So when we have a property with us, there are some options related to the property that can be performed, like you have a house or a car or a bike or anything for the purpose. You have the purpose of owning and using it for yourself. At the same time, you have the opportunity of renting it or leasing it to someone else and making money out of it, or maybe after some period of time, if the property that you have obtained is an appreciating asset, you have the opportunity to sell it for a higher price and make profit out of it. So this is what we call as a property. A property is an investment. So when we talk about an investment, there are appreciating investments as well as depreciating investments. So in this case, intellectual property is a property that is an appreciating asset that can sometimes be a depreciating asset also, depending upon the market. So so when we talk about intellectual property, all those properties that I told about in the previous before 10 seconds or something, those are properties which we call as tangible. You can touch them, you can feel, and you can use those such properties. But when we talk about intellectual property rights, it is an intangible asset. Intangible in the sense you can never touch or feel this particular property, but it remains with you as an asset. And at any point of time in your life, you can sell it to someone or rent or lease it to someone or use it for the purpose of your own. These are the things we call as intellectual properties. So the word intellectual comes out of the creativity. So when you create a property out of sheer your intellectual abilities, those properties that is created out of your sheer intellectual abilities are called as intellectual properties. And when such a property is registered with the government, and if the government is issuing you a certificate, we call it as an intellectual property right. It means any creation that comes out of your mind, unless and until it is registered with the government of India or the government of any country for the purpose, we cannot call it as a protected intellectual property or a protected creativity. So any kind of intellectual property has to be protected through registration. That is where we call intellectual property right. A property created out of creativity and registered with the government is called as intellectual property rights. So when we talk about creativity, we have different set of peoples. People are creating in different ways. For example, if we think about the people in the cine industry, they are creative in creating new pictures, new movies, songs, photography, and paintings, poetry, etc. They are quite creative in that manner. And when we talk about science professionals are creative in creating new machines, new structures, software, hardware, machine designs, and they create new parts, they create new integrated circuit layouts, and they create new materials and manufacturing processes. So anything that's related with science are created by science professionals. And those people who are in the biology department of the science department or of the as a science professional, they work with viruses, bacteria, algae, and some machines that is related to the biology. And such creativity are from the people who are inside the biology departments. And when we think about business professionals, independent of what is their education, when people come into the business, they are creative in business itself. So they create new brands, they create new business methods, and they create new business theories, they create new processes, new recipes, etc. So when a creativity from any person comes out in different aspects and different manners, and all that categorization of this particular creativity depends upon what is their hidden talent or what is the talent that they have nurtured within themselves to make sure to become a creative asset. So intellectual property can be obtained for all such types of creativities. Any creation that is related to cine industry, any creation that is related to science or scientific inventions, or any creativity that is related to biology, or any creativity that is related to business. These are the basic things in which intellectual properties can be obtained. And such intellectual property have certain classifications. Fine. So in general, we have different types of intellectual properties. Like I told you, there are people with different aspects of creativity. We have different types of intellectual properties. Number one, we call it as a copyright. From the word, you can very well understand any creation by nature, if it is able to be copied and created as a business, just by copying, you can sell it to the market and make a business out of it. Such an intellectual property come under copyrights. The word means the right for a person to copy someone's creation. That is what is copyright. So copyrights, anything that can be copied and done as a business in the market. For example, a picture can be copied and printed and done as a business. A movie can be copied and stored to a DVD or something, or any storable means, and you can sell it to the market. Recently, we have OTTs, the OTT rights. We have some songs, we have lyrics, we have compositions, anything for the purpose, any creation. If it is able to be just copied and sold to the market outside, it is a copyrightable subject matter, and they come under copyrights. So when we talk about the second type of intellectual property, we have that is trademarks. What I have mentioned there near copyrights is the validity of the intellectual property. A copyright is valid until the life of the author and 60 years after his death. So it means when we create a song, or when we create a picture, or when we create any copyrightable intellectual property, the validity once registered is until the life of the author, and from the life of author, it's valid for another 60 years. And the next type of intellectual property we are talking about is a trademark. So trade means business, mark is symbol. So any intellectual creative property is created that relates to a business as a symbol. Any intellectual creation that relates to a business as a symbol come under trademarks. So what you see here is Yahoo, Adidas, everything. They are all symbols that represent the brand. So the business represented by a symbol come under trademark, and they are a separate type of creativity that is valid only for 10 years. Patents and designs, I will tell you what are these things in the upcoming slides. So we have another type of intellectual property, that is geographical indication. Geographical indication, it means if a creative product, the product may be natural, or the product may be created through the help of naturally available products. If the product becomes famous because of the creativity of a particular location of people, if a product becomes famous because of the creativity of a particular location of people, such an intellectual property is called as a geographical indication. For example, we have Banaras silks. So the people of Banaras, they started weaving such silk saris, and they started creating the name for such a silk sari. Because of this name, until today, Banaras silks has a name in the market. So this Banaras silk is a geographical indication. Likewise, we have Kanchipuram silks, and we have Kadalai Mithai from Kovilpatti. So all these things are famous just because of the place of origination and because of the creativity of the people in that particular location. That is, those creativities are called as geographical indications. And the next one is a trade secret. It is also an intellectual property. Though the foreign countries across the world, they have some law for trade secrets. In India, we don't have a special law for trade secrets at all. So what is a trade secret? In Tamil, we call it Thoril Ragasyam, right? So trade is business and secret is Ragasyam. So if we talk about Coca-Cola or Pepsi, the blend of this particular beverage is remained as a secret for the past almost, I guess, about some 100 years or some. So the reason why the blend of Pepsi, Coke, and such brewery dishes are very secret is because they are protected under patents as well as trade secrets. It means these trade secrets, which is protected under the law of that particular government or that particular country, the employees are not supposed to release any related documents outside to the market, even though they are leaving the company after being employed within the entity. In India, these trade secrets or business secrets are protected not by law. They are just protected by employment agreements, right? So when let's talk about Kalimar Bovento. So we have Bovento as a drink, and compared to all the other drinks, Bovento has a different taste. But still, the owner Kalimark makes sure that the blend is always kept as a secret. This secrecy is maintained only through an agreement with the employees, and there is no such law protecting the employer from protecting his particular trade secret. So when the creativity of a person lies into creating a new layout for integrated circuits, they come under semiconductor integrated circuit layout, and that is a separate intellectual property right. We have another one type of intellectual property, that is plant variety. Not all plant varieties are intellectual property protectable. If a plant variety is newly discovered or invented, if a plant variety is newly invented, if the variety remains novel, distinct, and uniform and stable for the next 15 to 18 years, only at that point of time, the government of any country will issue a plant variety right to the farmers of that particular location. So they come under plant varieties. And microorganisms patent, what we deal about in today's era. The reason why I'm talking through webinar and we guys, everyone are meeting together in a webinar is because of a microorganism called corona. So any microorganism which is not natural, if it is created by man, and if such a microorganism, a bacteria or a fungi or an algae or a virus, if such a microorganism which is created by human beings and not naturally available, if it is not harmful for human or animal or plant life, then the government gives a protection as a patent, and they come under microorganism patents. So these are the different types of intellectual properties. Based on the type of creation that we have, the intellectual property for which we have to apply differs. For example, if you have created a new picture, or if you have created a new drawing, and you say that the drawing is highly intellectual, you cannot apply for a patent because they come under copyrights. We can apply only for a copyright. Likewise, if a person who is not an engineer or who is not a science graduate or who doesn't know anything about science, but still he has invented a product, and that product looks different, and that product works in a different way, and he wants to claim for a copyright, they cannot apply for a copyright, they can apply only for a patent. So based on the type of the creation, the intellectual property for which we have to apply also varies. Okay, so I hope I have made clear on the types of intellectual properties. Based on our type of creation, we have to apply for different types of intellectual properties. Okay. So now we are getting into the word research. So when we talk about research, there are two aspects. One is searching for the pre-searched and searching for the unsearched. It's like some people conduct a groundbreaking research, which will be of a type that no one else have touched so far. That is a search for the unsearched. And searching for the pre-searched is like continuing a research of someone else which has been left somewhere, or continuing the research of someone else which has stopped or passed somewhere. In these two cases, the maximum possibility of being more creative is when we are searching for the unsearched and not when we are searching for the pre-searched. So this is the basic aspect. And when we talk about research, there are two aspects. For one particular group, research is always about spending, and for the other particular group, research is always about earning. Let me tell you the people who earns out of research. Today we are living in a digital era, and every one of us are having a smartphone in our hands, and all the smartphones are today equipped with advanced technology features. So all these features that came into our into the control of a palm are just through research. It was around 2000 or 2004 I saw the first mobile phone that has been launched in India, which was so huge, it was so heavy, and it had an antenna at the top. And from there, the research started working from every single company. From there, we started using a keypad mobile phone that is of a miniature size. and those keypads were replaced with resistive touchscreens. Resistive touchscreens in the sense the screen works based on the amount of pressure we apply on the screen. That is the resistive touchscreen. It works based on the amount of resistance created over the screen. Then people came out with capacitive touchscreen. A capacitive touchscreen, it means it uses the capacitance. It uses the concept of capacitance through the amount of electricity that is generated within our body. Our body has some level of electricity that is created, and through the blood flow, this particular capacitance or this particular electricity flow is made use of with the mobile phone touchscreen. And from there, they came up with a feather touch. And from there, they came up with curved screens, and they came up with fingerprint sensors, and they came up with face detection. Today, the fingerprint sensors were all totally evaded, and we have the fingerprint sensors on the touchscreen itself. And the future goes on, right? So, who are making money out of research means the people who are employed or the people who are running businesses, they make money out of the research. Every single penny invested inside a business will be taken back at least 10 times or 100 times out of the expense that is made for a research. Unless and until a company is sure that it can make at least 100 times of money out of the investment that is made into a research, they will never get into that particular aspect of a research. So these are the people who earn out of investment in research. And when we talk about the people who for whom the research is always about spending, that is in most cases in the life of academicians, especially, and for educational institutions. So as educational institutions or we people, when we think about research, may be supported by the government or maybe supported by our own funds, we will always be cautious about what is the amount invested into the research, because we very surely know that the amount is not going to come back to us and it is going to be an expense. So for across India, for most educational institutions, research is all about spending. And for companies across the world, research is all about earning. And the last thing I wanted to tell you is research is what is fueling the business and the market economy. In 2004 or somewhere, it was very hard to find people who were ready to invest maximum about of 20,000 rupees on a mobile phone. If I'm not wrong, that's actually the fact. People were not ready to invest 20,000s or 15,000s in a mobile phone. But today, we are able to see people who are ready to invest even 1.5 lakh on a single mobile phone, which has a brand and which has a quality. It is because this particular research is fueling the business and the market economy. It means the money that has been earned by one person is under circulation through different organizations and through different products. This is what we call as a research. So this is the basic thing of a research. We identify a problem, we come out with an idea, or we come out with different set of ideas, and we refine the ideas and we come out with a solution. It is at this phase we are in a position to decide how we are going to publicize the solution that we have taken for a research. What happens in the industry and what happens in the institution are quite contradictory to each other. In industries, what happens is we first protect and secretize whatever is our research, number one. Once the research is complete, or even before the research is completed, we will always ensure that we take the legal ownership for the research conducted. We will always think about transforming the expenses into investment so that they are converted into assets, and always think about creating an option for making money, and we always transform the expenses into investment. This is the way how industry does research, and the way in which institutions do a research is, even before the research is complete, or the moment a research is complete, without even thinking about the monetary benefits that a research can earn back, institutions try to display and publicize all the creations or all the research that has been carried out. And very few institutions in India, they take ownership for the research conducted. but they just leave out to the world or give out the research output to the world free of cost as journals or publications. This publication or this articles or these things always retain forever as a paper, and it can be used only for the institution's academic benefits, maybe during what do we call inspections, or maybe for the people who want to switch the jobs, or who want to apply for a promotion. So these research works usually retain as a paper and used only for career purposes, and in most cases across the country, for research, academicians invest money from their own pockets. If I'm not wrong, please correct me if I am wrong. Is there anyone who opposes this? Okay. Fine. So when does a creativity transform into an intellectual property? I told you, unless and until you protect your intellectual property with a government, you cannot claim that to be a protected creation. Fine. So for the government to issue as a certificate that the invention or the creativity is protected, the creativity has to be novel, it has to be non-obvious, and it has to be business viable. It means the creation that we have created should somehow be made useful to an industry, or somehow be able to be used by an industry. This is the basic aspect for any creativity to be transformed into intellectual property. It has to be novel, it has to be non-obvious, and it has to be business viable. It should have some business viability. So within that, let's get into one of the costliest intellectual properties in the world. And we can even call it as a lottery, which can maybe making crores in future at any point of time, or it may even sometime remain back as a document, or remain back as as an academic achievement for a longer time. But it all depends upon the time, luck, and the amount of impact the product or the creation that creates in the business market. So when we think about a patent is the real game between the past, the present, and the future. A patent is the real game between the past, the present, and the future. Fine. So let me take the mobile phone itself as an example. It was in the year 2006 or 7, the first Android mobile phones were reached to the market. Android was an operating system. And those times, Samsung mobile phones or any mobile phone from a developed country that is launched in India were extraordinarily costly. So what we did was we used to buy mobile phones that were made from China or Korea. The only name that we named for these mobile phones were, when we discuss with our friends, we usually tell, did you buy a China set or did you buy a Korean set? These are the two words that we were discussing. So when Android started becoming cheaper, when Mr. Sundar Pichai started leaving Android as a freeware out to the market, many mobile phone manufacturing companies, they started working on creating Android mobile phones, and from there the word Android started coming out. People started discussing about what is the version of Android you have. Yeah, I have Android 6, I have Android 7, I have Android 8, 9, 10, 11, 12. So people started discussing about the version of Android because of the Android mobile phones. From there, the word Android was totally forgotten. Today, we started talking whether you have bought a Vivo mobile phone or an Oppo mobile phone. We even do not consider what version of an Android that particular mobile phone runs. Does anyone know what is the version of your mobile phone that you're using? No, very rarely, because the versions keep updating. We today just have the pride and prestige of the brand in which we own an Android mobile phone. This is what is the case. Or this was what the past of an Android phone, the present of an Android phone, and the future no one can predict. Now let me come into the brand called Apple. The past of Apple, the first mobile phone, the Apple mobile phone came to the market in around 2000s, I guess. Yes, the past of an Apple was an Apple. The present of an Apple iPhone is an Apple iPhone, and the future of the Apple iPhone will also be Apple iPhone, where people will always keep talking only about the word Apple, and they will never start, or they will never have a shift towards the brand, or they will never have a shift towards what they are owning. So this is what is the past, the present, and the future of Apple, the past, present, and future of Android. The reason why Android did not have a definitive future was because the Android was given as a freeware. The research, the investment, everything made was given out to the market as a freeware without a patent, and any creation that is not protected with a patent will end up nowhere. And any creation, even though it is extraordinarily simple, if it ends up to the market, or if the research outcome ends up to the market as a patent protected creation, then the past, the present, and the future will always remain the same. This is what is the power of the word patent. So across the world, the WIPO, World Intellectual Property Organization, controls all the patents, all the patent offices of different countries. In India, patents are controlled by the office of the Controller General of Patents, Designs, and Trademarks. Fine. Now we are getting into the criterion for patenting. Number one, it should be a patentable subject matter. I will tell you what are not patentable subject matters and what are patentable subject matters in the next slides. Next one, it should have inventive step. Inventive step in the sense your creation should definitely have at least a considerable level of inventiveness, and it should be novel. I told you it should be non-obvious, and it should be useful and industrially applicable. Either be able to be used by an industry or able to be produced inside an industry. So these are the basic criterions for patentability. So before getting into what can be patented, let me tell you what cannot be patented. Before we start with this, I just have a question. Can someone unmute your mic and tell me, am I audible, and is the way of my deliverance clear? Someone there?
Yes, sir. It's clear.
Fine. Okay. Thank you. Thank you. Okay. Now let's get into what cannot be patented. In the past years, I started my patent career. I started my intellectual property career in the year 2015. It was after a search of about 8 years. My first inventions work was completed during the 2008. And right from 2008 until 2015, I was searching for people who can exactly tell me what is a patent and what can be patented and how it can be patented. So I spent 8 years in knowing what can be patented and how the patent process can be done. And it was in 2015 I came to know how a patent can be filed. And obviously, I spent a lump sum of money. The first patent, I guess I spent about 2.5 lakhs in it. It was a very costly lesson for me. The reason behind this was that Indian academia had no idea about patents. That includes an university and very few elite universities who are in the tier 1 and tier 2 category. They know what is a patent and they use the patents in an effective way. So this happened for me that I had a very costly lesson to learn what is a patent. It was that time I decided, okay, I'm going to take this as my ambition to insert the thing of patenting to all the institutions across the country in tier 2 or tier 3 or tier 4 or tier 5. So this was my ambition. And over the period in the year 2016, I got my first national award on intellectual property rights. And recently in 2021, Daily Hunt News featured me as the man behind the surge in India's academic patents. So I'm very happy for this particular thing. And this mission is quite continuous. Fine, unless and until I'm able to achieve a condition where I can create an inventor from every single student and faculty out of an institution, the mission is never accomplished. Let's get into what cannot be patented. Any creation. Okay, the reason why I got into this subject matter was because during the past 6 years of my journey as an intellectual property expert across 200 institutions across the country, many people come to me and many people even ring up me and ask to me whether I have created this thing, can I patent this? I have created this thing, can I patent this? So many of the creations, they come under non-patentable subject matters. Let me tell you what are not patentable. Any creation that is against well-established natural laws cannot be patented. Even though you have found out, even though you have a solid evidence, you cannot patent any creation that is against well-established natural laws. And as I already told you, for microorganisms, any creation that is harmful to the human or animal or plant life on Earth, even though it is extraordinarily wonderful creation, it cannot be applied for a patent. Scientific theories, abstracts, or discovery of a living or non-living substance in nature. When we talk about discovery, the word very clearly says it is discover, uncover. We are just going to open the cover of something that is already present in the universe or the earth, which cannot be counted as an invention. That is the reason discoveries or scientific theories which cannot be proven or which is very tough to be proved, or mere abstracts or discoveries cannot be filed for a patent. Another chemical form of an existing substance without improved efficacy. For example, we have a tablet called paracetamol. Paracetamol is it's actually, I forgot. It's I think trying to tell you something acid related. Fine, forget about that. Paracetamol has a chemical composition. I have the same in the future slides, in the next slides. If suppose you are able to create a paracetamol drug of the same or a new form of a new chemical form of a paracetamol drug, and if you say that I have created a new form of a paracetamol, but the same form, the same chemical form doesn't have any significant effect on the efficiency, then it cannot be patented. So a chemical form, another chemical form of an existing substance, if it does not have efficiency improvement, then it cannot be patented. And admixtures resulting in aggregation of properties. So if we talk about sodium and chloride combined together, sodium chloride, okay, fine. It is mere aggregation of properties. Likewise, we have when we mix of chemical compounds, and we say I mixed all these things. 1 + 1 is equal to 2, and 2 + 1 is equal to 3, and 3 + 2 is equal to 5, and 5 + 5 is equal to 10. It is aggregation. Fine. The patent office will not accept that as an invention. But if the 1 + 2, if you're adding 1 + 2, if it becomes a multiplication factor, when you're going to add two different substances or 4 different substances, instead of aggregation, if it is a multiplication, then that can be patented. Mere arrangement and rearrangement of components that are working independent to each other. Fine. So many cases come to me and my office from different academic institutions in this way. Sir, I have joined a fridge and a MP3 player together. Can I patent it? No. Because the fridge is going to do its work separately and the MP3 player is going to do its work separately. It is mere arrangement and rearrangement of components that are working independently. That is not patentable. But if you are able to create an invention in which 2 or more products are arranged and rearranged, if they are working interdependent to each other through a common medium, that can be patented and that can be counted as a single invention. New methods of agriculture and horticulture, not patentable, but machines created for agriculture and horticulture are patented. So the difference is புதிய விவசாய முறைகள், hydroponics, aquaponics, likewise we have soilless culture. There are many methods of doing agriculture and horticulture. So if you are creating a new method, it is not patentable, but the machines are patentable. Medicinal processes or therapeutic processes for humans or animals. So medicines are patentable, but the process of treating a person through a therapy is not patentable. This is where the difference is. Plants, trees, their parts, biological processes of production in nature except microorganisms. So any method of creating new plant or a tree, or any process of multiplying the number of plants or trees in nature, that is not patentable except for microorganisms. If you are going to create a medium or a solution to multiply the amount of microorganisms or decrease the amount of microorganisms, that is patentable. But the process of production of plants or trees are not patentable. and this is most important, and many people come out with such things. Mathematical models or business models are not patentable in India. In India, a new mathematical model, no. A new business model, no, even though if it is novel. And computer programs or algorithms are also not patentable, because a computer program is something that can be taken as a printed version and be sold to the market, or that can be copied and pasted in another electronic device or a computing device and run as a program. So computer programs and algorithms, they are considered as copyrightable subject matters and not inventions. Next one, anything related to copyrights, I already told you, not patentable. Scheme or a method for playing a game or doing something with a mental ability, not patentable. Presentation of any information. For example, you have a new information, or you have created something new. You have just presented the new information, and you call or you claim for a patent. No, you have a new type of a training methodology through which you present the information that you have in a different form. Not patentable. Topographies of integrated circuits. No. And traditionally known concepts by traditional knowledge, especially in India, are not patentable. In India, we are a people of different tribes and culture across the country. We have different states, and every single state have different tribe versions, and every people and every tribe has different medical processes and therapies and treatment processes, and all these things are accounted by the government of India within a library, and the library is called Traditional Knowledge Library of India. You can take a note. It is Traditional Knowledge Library of India. So any information that is present in the Traditional Knowledge Library of India, and you call it that it has a your invention, it cannot be patented. Traditionally known things or traditionally known processes cannot be patented. And the last two things, very, very important. Never file for a patent that is related to atomic energy or any material that is related to nuclear reactions. Such patents which is filed to the government of India are considered to be related to the protection of the country, and the person who has filed a patent for this particular thing will be taken under the custody of the Defense Department. And Section 35 of Patents Act, what it says is, no Indian citizen, I'm very clear, no Indian citizen who is a resident in India, resident in the sense who is residing in India, is supposed to file a patent in any country out of India without the permission from the government. It means when we are an Indian citizen and we are going to file a patent, it means the property remains as a national property. Being a citizen, the intellectual property becomes a national property. Unless and until you apply to the government and take a permission for filing a patent outside the country, you are not supposed to file a patent in any country apart from India without the permission. If suppose the same has been done without permission, 2 years of imprisonment is also possible. So always make sure that you are cautious on filing a patent outside India without the permission from government of India. So these are the things that are not patentable in India as per the Indian Patents Act 1970. Now I'll tell you what can be patented. You can patent a process or a method. The process of manufacturing a machine, the process of manufacturing a product, or the process of preparing a dish, anything. You can apply for a patent for a process or method of doing something. You can apply for a patent for products. You can apply for design patents. You can apply for chemical composition patents, or you can apply for microorganism or plant variety patents. Let me get it very clear. So before we talk about go in depth of science, technology, research, okay, let me make it quite simple on what is a process patent. Right? Let me assume that you are going to create a rasam. Fine. We all know rasam. Foreigners call that as pepper water. And my uncle calls that as pepper water. Rasam is called as pepper water. So there are different types of rasams that is available in the market. For preparing rasam, we have a specific method of preparation, right? Let the method of preparation be separate. If you are able to create a new process for preparing the same rasam, and if the process is able to be used by an industry, it means a machine should be easily able to understand your process, and the machine should be easily able to produce the rasam. In that case, your method, your new creation, your new process can be filed as a patent. So this is where this is how we apply for a process or a method patent. Once it is patented, and if your rasam becomes very famous, from that point of time, people who goes to hotels, every single hotel, they will ask for this particular variety of rasam. And if your rasam is very famous, then those people in the hotel, they will be paying you for every single cup of rasam that is being produced. All the best. And we can file for a patent for a product or utilities. So what you see here is a chair, and the second one is also a chair, and the third one is also a chair. But the use or the utility changes. Product number 1 cannot be moved. The red chair cannot be moved. Number 2 has a movable wheel which can be moved so that the utility changes. And number 3 is a self-parking intelligent chair, where the chair will communicate with all the other intelligent parking chairs and will park itself under the table very, very comfortably. So this is where you can file for a patent for your creation that is of a use of utility. And design patents are quite different from patents. When we talk about patents, patents are into technology. They will ask how it works. If suppose, let us assume that you are a creator of this intelligent parking chair. When you file for a patent, the patent office will ask you how it works, how it communicates with the other chairs, and how it moves, and how are the wheels arranged, and what are the different systems present inside the moving chair. This is what is called as a utility patent. But for a design patent, they will not ask you how it is going to work. They will not ask you what is the technology inside. They will not ask you what are the components present inside. They will ask you nothing. They are going to give you a patent only for the look and appearance of the product. This is what is a design patent. On the top left, you see the Samsung mobile phones, and on the top right, you see Apple mobile phones, very clear. Samsung has a rectangular and elliptical home button. Apple has a circular home button. The screen design or the body design of mobile phones of Apple and Samsung both are different. And in the bottom, you can see water bottles. Even though these people are selling water bottles to us, the shape of every single water bottle changes and remains fixed. It is because they have not sold us the water, they have sold us the bottle. Even from about some 20 or 30 meters of distance, just by seeing the bottle, you will say it is an Aquafina. Even at 20 or 30 meters of distance, just by seeing, you will say it is a Bisleri. It is because the design patent reserves the right for the bottle shape and look and appearance. This is what is called as a design patent. Chemical composition patent. As we spoke about paracetamol, it is phenol nitrated to para-nitratoluene. And the para-nitratoluene, when it is acetylated, it is called paracetamol. It is a drug. Even though the base remains the same, the efficiency of the tablet in terms of taste has been improved by a lady in USA who filed for a patent in the year 2014. It is a tablet of paracetamol containing encapsulated flavorant. It means the paracetamol will no more be bitter. So these are chemical composition patents. And microorganisms, I've already told you, any microorganism that is not harmful for human or animal or a plant, it can be patented. So I hope I'm clear on what can be patented and what cannot be patented, and the different types of creations that can be filed for a patent, and the difference between patents and designs. Patent talks about technology, working methodology, and the components. Design never talks about the technology or working methodology or the components. It just talks only about the look and appearance. So this is the basic difference. So getting a patent for a utility is quite tough because you have to be novel, but getting a patent for a design is extraordinarily very, very easy. You have to be creative. That's it. So in India, what are the different stages in filing a patent? Number one, you have to go for an NDA. NDA in the sense, when someone comes to you, or if you want to tell your invention to any person from whom you are asking help to file for a patent, never ever disclose your invention or your idea to the person without a non-disclosure agreement. NDA is a non-disclosure agreement. In today's market, this is a very huge business for patent professionals across the world. They collect the ideas from many people and they just transfer such ideas to industries. Without a non-disclosure agreement, the people also tell those patent professionals about the creation. And once the idea or the complete thing goes to a factory or to an industry, they make use of it. So never reveal your idea to any person without making a non-disclosure agreement. Patentability check, it is optional. Prior art means anything that is any creations that is already available in the public medium as a product or in the internet, which will make your invention not novel. Prior art, if there is something or a same kind of invention that is available in the market, it will make your invention not novel. Then we have to draft the patent application. Drafting a patent application is a process that is technical and legal. The reason why we call it as patent drafting and not patent writing is because so when we buy a land document, we don't write our own registration document, do we? No. The reason why we give the registration document to be written with a professional is because it is a legal document that is going to stay forever as a protection behind your property. Likewise, if a patent has to be safe enough, if it is going for grant, then the drafting it is better for the drafting to be done by a professional. And this is not the case forever. This is not the case always. It depends on what type of or what is the level of protection you are going to seek for your creation. Then it goes for patent filing. So after a patent has been filed, it will go for a preliminary examination and they will publish the patent application. Then we need to file a request for examination. And if a patent has to be filed, or if your patent is filed by some other third party, like if your uncle or if any one of your relative is asking you to handle his property on his behalf, you will collect something called as a power of attorney, right? Likewise, if any third party is supposed to process your patent, your creation with the patent office on your behalf, it is mandatory for the person to produce a power of attorney on your behalf, stating that he is authorized to handle your invention. This is where it becomes very critical. And once these documents are done, it will go for publication. The patent application will be published by the patent office. According to the Indian law, a published patent application is equal to a granted patent. A published patent application is equal to a granted patent. It means from the date of publication, the person can use his invention as a commercial product. Then it goes for examination. Examination is the phase where the patent office will go through your invention very thoroughly, and they will give you a report stating whether your invention is patentable or not. So like how we go to police station, we file a complaint, they give us a first information report. In the patent office, they give us a first examination report, that is FER. Once this comes out, we have to draft and file a reply, a legal reply to the patent office for all the objections they have mentioned. This is the drafting and filing, a reply for the first examination report. And then we can go for maybe if suppose the controller is convinced, if suppose the patent office is convinced that your reply is satisfactory, they will give you a grant of patent. They will give you the document of registration. But if the controller or the patent office is not convinced with your reply, they will call us for a hearing. Hearing can be attended either through video conference, or like how people argue in the court, right? When there is a hearing, people argue in the court. Likewise, your attorney or yourself as a person, you have to argue with the controller on what basis your invention is really novel. And based on the hearings proceedings, we need to also submit a written submission to the patent office. Once that is done, the controller will say either the patent is granted or not granted. So this is the overall process. In India, we have one particular thing called as a post-grant opposition. Opposition means any person in India or any Indian or any person across the world can oppose the grant of your patent on any grounds which comes under, as I told you, non-patentable subject matters in section 3, the first thing I told. So if a person objects you that you have your patent grant is not legal, then the patent office will take into consideration, and the same will be taken as a handling of oppositions. So this is the process that is followed for a patent in India. Usually a patent will take about 4 to 6 years for getting granted. But in certain cases, if the patent has been filed by a government institution, the patent will be considered for processing within 1 year. If the patent has been filed by at least one women applicant in the sense, if there are some 4 or 5 people going to apply for a patent and one person or one applicant is a woman, then the patent office considers the patent to be processed within 1 year, number 2. And for startup companies, again, the patent office processes it within 1 year. Apart from this, for all others, the patent process will take a minimum of 4 to 6 years. Right. Regarding the fees of patenting, okay. So it's almost 3:30. So should I continue or should I wind it up a little earlier? Organizers, can you tell me?
Sir, you can continue up to 3:45. Take another 15 minutes.
So I think I will take
another 15 minutes.
Thank you. Fine. So what are the types of patents in India? We have provisional application and a complete specification. Provisional means, so when we finish our degree, even before the degree certificate came, comes, the university will give us a provisional certificate, right? It means this document is valid only until receiving the degree certificate. Likewise, a provisional specification is not a complete detail. You have an invention, but you're not sure whether it is going to be completely able to be completely defended as an invention or not. Then you can file for a provisional specification, but the provisional specification will not be published. And within 12 months, you have to file the complete specification. Complete specification means it should particularly describe the complete process of the invention and the method, the components and everything. So in that case, the complete specification will be published by the patent office. Then you can go for examination. Then you can go for grant. The cost for filing, it is about 1,600 to at the max 5,000. For filing and publication, it is 4,100 is the fees, government fees, until filing and publication. And if you are going to hire an attorney, the maximum fees will be 14,000. It will not cross that. For filing a patent and until the grant, the fee that has to be paid to the government is 8,100 for individuals. Even for academic institutions, the fee remains the same in current scenario. Earlier, it was like when we file a patent in the name of individuals, then the fee will be very less. But for institutions or for large entities, the fee used to be 4 times the value of individuals. But in today's scenario, if a patent is going to be filed by an educational institution or the patent is going to be filed in the name of individuals, the fee to be paid to the government is only 8,100 at the max. And if the application is going only for publication, then the government fees is only 4,100, and the maximum fees you have to pay to a professional, to a patent professional, is 14,000. You can do it yourself or you can do it through a professional. The next type of application or the next type of patent is a PCT and conventional application. We don't have time to discuss this. Ordinary application or Indian patents, PCT and convention, or international patents. International patents in the sense a patent filed by a citizen of one country in a separate country in another one country is called as an international patent. But there is no one single patent for all the countries in the world, because patents are jurisdiction specific. It means a patent filed in India is valid only in India, and a patent filed in America is only valid in America, and a patent filed in China is only valid in China. It means a patent filed in India can be manufactured by the Chinese without taking any permission from any person from India. But if the Chinese product is going to be sold in India, at that point of time, the Indian patent holder can oppose. This is what I mean. A patent is a jurisdiction specific. But when we have to file for a patent for all the countries across the world, then we can go for a PCT application, which is common for 140 countries. the PCT applications will be considered as an international patent application, and it will be published in the patent scope database. This is where it becomes international patent. The publication will be done in English and French languages. But if we are going to file a patent for a country which doesn't have English as the official language, then we have to translate it to their language and file it. For example, Japanese Patent Office does not accept English patent specifications. They accept the patent specifications only in Japanese. Likewise, Chinese, French patent offices, European patent offices, German patent office. So all these country people, they accept patent specification in their own language. But for PCT application, we can directly file the English application itself. It will give us an international search report. And from the date of filing, you have 31 months of time to decide which country you're going to file for a patent out of the 140. And international application, if you are going to file for any specific country, always remember, no Indian attorney is eligible to file a patent in another country. Indian patent attorneys are eligible to file patent only in India. They are eligible to file patents across the country, across the world, in any country. But for prosecution, when it goes for prosecution, when it goes for hearing, or when it goes for examination, only the attorney in that particular country is eligible to appear on behalf of you. So this is basic difference. An international patent publication will cost a minimum of 10,000 rupees and a maximum of 70,000 rupees, only for individuals, right? So now I have another 10 minutes. So strategies, let me make it very clear. Define the purpose. If you are going to do a patent only for academic purposes, it will be better you stop with publication. Because as of now, published patent application is equal to a granted patent application. Because when you are going for a grant of a patent, it will cost you a huge sum of money, and the process is quite cumbersome, where it goes for litigations, and it goes for examination, prosecution, and everything. So define the purpose for which you are going to create a patent or a design. Design patent, the maximum cost per design patent, including the design until the grant, will be 25,000 at the max per design patent. And there is no regulation, or there is a different system that is going on in India. First applicant 20,000, second applicant 50,000, third applicant, no such things. Because as per the patent office things, all the applicants are given an equal right. But in terms of academic valuation, first, second, and other people are given a different valuation. That is the reason behind the pricing system in the market. But as per law, all the applicants are given equal priority, equal weightage, and equal share. So when you're going for academic purposes, go only for publication. That is enough. And if you want an international patent for academic purposes, never file a patent outside the country without the permission from Government of India. The person who can cheat you and who can collect the money from you, if he is filing a patent outside India on your behalf, the person who filed will never be got caught. Only you will be answerable before the court on taking permission from the Government of India, because the patent remains in your name. Never file an international application without the permission of the Government of India. If suppose you are going to create a patent as an asset, then go for grant. Unless and until you are 100% sure that your invention is extraordinarily novel, never go on investing money on any patent, because the ability to take back the investment is quite difficult. And if a patent is not granted, you can never ask back for the money from the attorney or from the agent, because he has done his duty to carry on the entire process of patenting. So never ever invest a huge sum of money on any invention which you do not consider it will go for a grant. So these are the cost factors for budget. For publication of patent applications, any number of applications or any number of applicants for a patent application, maximum it will cost 11,000 rupees. You can also transform your own published research papers into patent publications. At the max, it will cost you 14,000. International publication. When you're going for international publications, make sure your invention is extraordinarily wonderful. Only then go for international publication. If not, do not waste your money. And the maximum direct publication, the cost will be 40,000 to 70,000 rupees at the max. And if you're going for grant of a patent, you will end up spending a minimum of 60,000 rupees to a maximum of 1 lakh, and the situation changes. And if you're going to file for a patent in any other country, except India, all other countries, attorneys are charging on per hour basis. Per hour in the sense, for how many hours they work, you are supposed to pay them. So the cost will range somewhere between 1 lakh to a maximum of 8 lakhs per patent. This I'm talking about only the patents, not about designs. Designs in India, the maximum fee is only 25,000 rupees. That includes the designing charges also. So limitations, let me not discuss all these things. If there is some other time, I will tell you. But there are two things. No person in any country can assure you the grant of a patent in any way. Never believe a person who says, I will give you 100% grant. That is impossible. The decision of the patent office remains final. Okay. If anyone tells you that they will get 100% grant, they are fake and they are not qualified patent professionals. Number two, if any third person is going to file a patent on your name, on your behalf, ask for their patent agent ID or the patent attorney ID. If they are not able to produce you the patent attorney ID, it means they are fake people and you do not, and it is better you avoid them so that you do not end up with wasting your money. And even if you're going to file a patent across in other country, in some other country, then ask for the identification number of the patent attorney and you can check whether he is original or not within the country's database itself. Fine. So I hope I made this session quite useful. I thank Shri Nehru institutions for giving me this opportunity. In case of any queries which cannot be asked during the session, at the end of the session, you can write an email to me to this email ID. It is prem@inansip.com. I'm always available in WhatsApp. Currently, I'm in Africa, so I will not be available on my Indian mobile number on a normal call. I can solve your queries through WhatsApp. My African mobile number is there in the first slide for someone. That is the reason I just made sure that it is visible in the beginning. So thank you so much for the opportunity. This is the website where you can find all the data about intellectual property rights. There is a blog within this website where I have actually rewritten the legal terms in a normal English that any person can understand. And my Indian patent agent ID is 3311 Indian patent agent. Thank you for the session and thank you everyone for the patience. Thanks. If there is any questions, you can ask me.
Thank you, sir. Participants, if you have any queries, leave a question in chat box. Now the session is open for discussion.
I think it will take a lot of time for people to type and post it in the thing. You can unmute your mic and you can ask your queries if you have any.
Please unmute yourself and please raise your questions about this topic. Okay, now it's vote of thanks. Gratitude is the fairest blossom which springs from the soul. Now I request Dr. S. Meenatchisundaram, Associate Professor, Department of Microbiology, to propose vote of thanks.
Good evening to all. Gratitude creates the most wonderful feeling. It can strengthen friendships and it makes us better men and women. It's my honor to propose a vote of thanks on this special occasion. First of all, I would like to thank our chief guest, Dr. PREM CHARLES, founder, Allinnov Research and Development Private Limited, India, for accepting our invitation and sharing valuable information with us. Thank you, sir. I wish to thank our management for their support and encouragement in the organization of this program. I also extend my heartfelt thanks to our principal, Dr. P. Subramani, for his enormous support in the organization of this program. Thank you, sir. I wish to thank our Center for Research and Development, IPR and Institutions Innovation Council for organizing this program. I take this opportunity to extend our most sincere thanks to all the heads of the departments, staff members, and participants for their support and cooperation. Once again, I thank everyone present here for sharing this special moment with us. Thank you very much.
Thank you.
Participants, please fill the feedback link posted in the chat box. Thank you all.
Organizers, it will be better if some feedback forms can be shared to me, those positive as well as negative, so that those negatives are most important, where I can improve myself on any information that can be made further elaborated or that can be removed from the session or something. So share with me the positives and negatives of the session once the feedback forms are collected, and I thank you.
Sure, sir.
So may I leave?
Participants, please fill the feedback link posted in the chat box.
Organizers, may I leave the meeting?